The law of contract, void. In general, for a contract to be considered legally binding, it should fulfill the following characteristics. A clear offer and acceptance, something of value that is given in exchange for a promise, which is the consideration. Both parties have the intention to create legal relations. All parties must have the capacity to enter into a contract and freely consent to the contract. However, sometimes an action or an unforeseen event can dramatically affect the validity or enforceability of the contract, in which case the contract can be rendered void, thereby releasing the parties from their obligations. A void agreement cannot be enforced by law. This video will explain factors that can render a contract void. At the end of the video, learners should be able to achieve the following learning outcomes. Let us start with defining void contract. Section 10 of the Contract Act 1950 emphasizes that for a valid contract, the consideration or object must be lawful and is not declared as void. In law, void means of no legal effect. An action, document, or transaction which is void is of no legal effect whatsoever, an absolute nullity. A void contract is a formal agreement that is unenforceable from the moment it is created. The law treats a void contract as it had never been formed. Further definition of void contract can be seen in the following provisions. Clause G of Section 2 of the Contract Act 1950 stated, an agreement not enforceable by law is said to be void. Clause J of Section 2 of the same Act stated, a contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. The two provisions emphasizes that an agreement that consists of unlawful consideration and object is deemed to be void. Meanwhile, sometimes after the formation of the contract, changes in the nature of the agreement may cause the contract to be void. We will now look into the factors that can render an agreement or contract void. In contract law, a mistake is an erroneous belief at contracting that specific facts are accurate. Both parties to an agreement are under mistake as to the matter of fact essential to the agreement. The agreement is void as per Section 21 of the Contract Act 1950. A mistake is basically a misconception of error. For an agreement void under mistake, the mistake has to be bilateral, meaning that both parties are under mistake. It occurs when both parties are falsely operating on inaccurate information. Bilateral mistakes can be problematic because both parties have misunderstanding of the contract and its terms. When both parties is not aware of the specific term of contract, there is no consensus at either. It can be difficult and even impossible to fulfill the requirements of the contract. Section 21 of the Contract Act 1950 listed the following criteria. 1. Both parties to an agreement must be under mistake. This is what I've mentioned earlier, which is the bilateral mistake. 2. Mistake must be of fact. And 3. The fact itself must be essential to the agreement. A mistake can be of law or of fact. A mistake of law is when a party enters into a contract. Without knowing that the law in the country, the contract is affected by such mistake, but it is not void. The reason here is that ignorance of the law is not an excuse. However, If a party is induced to enter into a contract by mistake, the contract is void. For example, mistakes by law. Hajar and Danny make a contract grounded on the erroneous belief that a particular debt is barred by the Malaysian law of limitation, so the contract is not voidable. The second type of mistake is mistake by fact. Mistake by fact is where both parties enter into an agreement or under a mistake as to the matter of fact essential to the agreement. The agreement is voidable. For example, A sells a cow to B for 80 ringgit because the cow is infertile. However, the cow actually is pregnant and actually worth 1,000 ringgit. Hence, the contract is void. Let's look at the case Couturier versus Hasty. Now, in this case, there is an agreement entered for a cargo of corn. The cargo had, however, perished and have been disposed on before the contract has been made. The seller then sought to enforce payment for the goods because the purchaser had attained the title of the goods and therefore bore the goods' risk of being damaged, lost, or stolen. The court held that the contract was void because the subject matter did not exist when the contract was made. The subject matter here is referring to the cargo of corn. What happens when a contract deemed void? Under Section 21, when both parties are under mistake as to the matter of fact, the agreement is void. Section 22 stated, any agreement made in reference to mistake to any law in Malaysia, not voidable. However, any agreement made as to the mistake of law not enforced in Malaysia is void. Section 23 stated, any contract caused by mistake of one party is not voidable. Hence, in any case of unilateral mistake, a plea of mistake will fail. Next is unlawful consideration. Section 24 of the Act 1950 listed consideration or objects of an agreement that are unlawful. The section stated the agreement is void if the consideration or object falls under one of the categories listed under Section 24. Meanwhile, Section 25 stated if any part of the consideration is unlawful, the agreement is void. What are the categories under Section 24? There are 5 categories stated in Section 24. 1. Consideration or objects that is forbidden by law. 2. Consideration which, if permitted, will defeat any law. 3. Consideration gains by fraud. 4. An agreement that involves or implies injury to person or property. And 5. A consideration that is immoral or oppose public policy. 3. Agreements without consideration. An agreement is void if it is made without consideration as per Section 26 of the Contract Act. For example, Ali promises to give Chua 100 ringgit for no consideration on Chua's behalf. This agreement is void as Chua did not provide any consideration in the agreement. 4. Agreements in restraint of marriage. According to Section 27 of the Contract Act 1950, agreement in restraint of marriage is void. The reasoning is we cannot enter into an agreement that is harmful to the population and the moral welfare of human beings. Let's refer to the case Low versus Pierce. In this case, the defendant promised to marry the plaintiff and failure to do so, he will pay £1,000 to the plaintiff. This agreement is void as one cannot enter an agreement refraining or restraining anyone to marry anyone else. 5. Agreement in restraint of trade. Section 28 of the Contract Act 1950 stated, every agreement by which anyone is restrained from exercising a lawful profession, trade, or business of any kind is to the extent void. We cannot create an agreement that restrains or refrains someone from conducting any work or businesses. However, there are exceptions to the provision. 1. Refraining one to carry out similar business within specified location in relation to business of goodwill. 2. Agreement not to carry out similar business to that of partnership within local limits prior to dissolution. And 3. Agreements not to carry out any businesses during the continuance of a partnership. In the case Wigglesworth versus Anthony Wilson, the agreement is void because it refrains the defendant from exercising or practicing his profession after the termination of his employment. 6. Agreement in restraint of legal proceedings. According to Section 29 of the Contract Act 1950, it stated any agreement that restricts absolutely from enforcing his rights to illegal proceedings is void. However, an exception can be made if the agreement allows for arbitration. 7. Agreements the meaning of which is not certain. According to Section 30 of the Malaysian Contract Act 1950, an agreement is void if it is uncertain or incapable of being made certain. 8. Agreements by means of wager. Section 31 stated, any agreement by way of wager is void. However, no suit shall be brought for recovering anything alleged to be won by wager. However, the only exception under this provision is for certain prizes for horse racing. And number 9, agreement to do impossible act. According to Section 57, subsection 1 of the Contract Act, stated an agreement to do an impossible act in itself is void. And according to Section 57, subsection 2, any contract that afterwards becomes impossible or unlawful after it was made, it is considered as void. For example, Ali and Ramlah signed an agreement for Ramlah to sing at a concert organized by Ali. Ramlah unfortunately passed away before the concert. Hence, the contract becomes